Hey y'all, it's Kim. So this is video number 2 of basically Jeffrey Epstein trying to get something tossed out of one of the complaints filed against him, blah blah blah. He was trying to get away with what he got away with, really. Anyway, it just says something about him trying to strike something from the case, like something about ex post facto or something like that. So basically, trying to increase the punishment after a crime was committed. Anyway, you just have to watch the other video that I just did because, anyway, it'll explain it more. But we are on page 6 of this document. It's like 22 pages. And I just broke it up because it gets a little boring when you're looking at court documents. It really does. It's like you're reading this stuff and you're like, I don't know what this is. I'm not an attorney. I'm just reading what it says. Some of it is explained in the paragraph, some of it's not, and some of it's like it's just over my head. I'll just be honest with you. I'm not trying to act like I'm super smart. I'm just looking through the documents to see if there's anything interesting in there. But anyway, so we're right here in this where it says in count 3 of her complaint, which is CL. The case is CL versus Epstein. She alleges that defendant Epstein knowingly engaged in a child exploitation enterprise as defined in 18 USC subsection 2252A, G, and 2 in violation of 18 USC subsection. Sorry, it went too fast. This thing is getting on my nerves today. Hold on, I gotta get down here. Okay. In violation of USC subsection 2252A G1. Subsection 2252A is one of the specific criminal predicate acts under 18. Now it wants to go slow. USC subsection 2255. However, subsection G of subsection 2252 was not added to subsection 2252 until July 2006. In attempting to assert a claim pursuant to 18 USC subsection 2255, plaintiffs, which is CL, is relying on subsection G1 and 2 of the criminal statute 18 USC subsection 2252A as the requisite predicate act. Subsection G of 2252A was enacted in 2006, effectively July 27th, 2006. See 2006 amendments published 205 to 48, subsection 701, added subsequent, blah, blah, blah. There's like a lot of this. Okay. If she alleged conduct by Epstein directed to CL occurred prior to the effective date of the statute, reliance on subsection G violates the well-entrenched constitutional principles against retroactivity. And that's the ex post facto thing that I was talking about. Let me see if that's still pulled up. I don't know if it is. Yeah. So an ex post facto law is a statute that retroactively changes the legal consequences of actions committed before the law's enactment, making something a crime that was legal. So let's just say, like I said in the last video, the only thing I can equate it to that I can think of right off the top of my head is that sometimes you will purchase, like, say, a firearm. You've gone to the dealership, you gave them your license, you did all this stuff. And then Congress comes back later, even the state law comes back later and says, okay, that gun is now outlawed. So now that makes you a felon automatically. And I've heard of people having like a bump stock or there's something else. It's some kind of thing that you can put on your arm, some type of wrist brace to make basically almost like your handgun, almost like make it a rifle length or something like that. I've heard of something like that, and they said that now those are illegal, but at the time you purchased it, it was legal. So that's the only thing I can think of right off the top of my head. But let's go back to the court case. Let me see, where was I at? Okay, if the alleged conduct by Epstein directed to CL occurred prior to the effective date of the statute, reliance on subsection G violates the well-entrenched constitutional protections or principles against retroactivity, and thus count 3 is required to be dismissed. If the acts occurred only after July 27, 2006, which defendant's attorney no cannot be true, CL would be 18 and not a minor, so the statute would have no application. Pre-July 2006, 18 U.S.C. subsection 2252A contains no subsection G as relied on by plaintiff. See in note 2 here too for complete statutory text of 18 U.S.C. subsection 2252A, and this is from 2004, and as amended effective July 26, 2006. Subsection G, which did not exist at the time of defendant's alleged conduct, now criminalizes the following conduct: child exploitation enterprises. Whoever engages in a child exploitation enterprise shall be fined under this title and imprisoned for any term of years not less than 20 or for life. A person engages in a child exploitation enterprise for the purposes of this section if the person violates Section 1591, Section 1201 if the victim is a minor, or Chapter 109A involving a minor victim. 110, except for Sections 2257 and 2257A, or 117 involving a minor victim. As a part of a series of felony violations constituting 3 or more separate incidents and involving more than one victim, and commits those offenses in concert with 3 or more other persons, which he kind of did, but I guess. Anyway, see in note 2 here too, it is an axiom of law that retroactivity is not favored in the law. So Bowen 488 U.S. At 208, and then some of these other ones in 1988, I guess. And then, as eloquently stated in Landgraf versus USI Film Products, and this is a case in 1994, the presumption against retroactive legislation is deeply rooted in our jurisprudence and embodies a legal doctrine centuries older than our republic. Elementary considerations of fairness dictate that individuals should have an opportunity to know what the law is and to confirm their conduct accordingly. Settled expectations should not be lightly disrupted. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal appeal. Kaiser 494 U.S. at 855, 110, whatever this is. Scalia J. concurring. In a free, dynamic society, creativity in both commercial and artistic endeavors is fostered by a rule of law that gives people confidence about the legal consequences of their actions. See General Motors Corp. versus Romine, I guess. This was a case in 1992. And then retroactive legislation presents problems of unfairness that are more serious than those posed by prospective legislation, because it can deprive citizens of legitimate expectations and upset settled transactions. Well, that makes sense. Okay. It is therefore not surprising that the anti-retroactivity principle finds expression in several provisions of our Constitution. The Ex Post Facto clause flatly prohibits retroactive application of penal legislation. Article 1, subsection 10, I guess that we clause 1, prohibits states from passing another type of retroactive legislation laws impairing the obligation of contracts. The Fifth Amendment's takings clause prevents the legislature and other government actors from depriving private persons of vested property rights except for a public use and upon payment of just compensation. The prohibitions on bills of attainder in Article 1, subsection 9 and 10 prohibit legislatures from singling out disfavored persons and meting out summary judgments for past conduct. See the United States versus Brown, and that was for 1965. The Due Process Clause also protects the interest in fair notice and repose that may be compromised by retroactive legislation. A justification sufficient to validate a statute's prospective application under the clause may not suffice to warrant its retroactive application. So usury, I guess, versus Turner Elkhorn Mining Company. And this for 1976. Article 1 contains two ex post facto clauses, one directed to Congress and then the other to the states. We have construed the clauses as applicable only to penal legislation. See Calder versus Bull, and that was from 1798. These provisions demonstrate that retroactive statutes raise particular concerns. Why does it keep going? Sorry. It just keeps going to the next page. I'm like, I don't want it to do that. Okay. So these provisions demonstrate that retroactive statutes raise particular concerns. The legislature's unmatched powers allow it to sweep away settled expectations suddenly and without individualized consideration. Its responsivity, I can't say the word, responsivity to political pressures poses a risk that it may be tempted to use retroactive legislation as a means of retribution against unpopular groups or individuals. As Justice Marshall observed in his opinion for 1498, the court in Weaver versus Graham, and this was something from 1981, the ex post facto clause not only ensures that individuals have fair warning about the effect of criminal statutes, but also restricts governmental powers by restraining arbitrary and potentially vindictive legislation. Yeah, I can see that. See Richmond versus J.A. Croson Company. That's from 1989. Legislatures are primarily policymaking bodies that promulgate rules to govern future conduct. The constitutional prohibitions against the enactment of ex post facto laws and bills of attainder reflect a valid concern about the use of the political process to punish or characterize past conduct of private citizens. It is the judicial system rather than the legislative process that is best equipped to identify past wrongdoers and to fashion remedies that will create the conditions that presumably would have existed had no wrong been committed. Stevens J. Concurring in part and concurring in judgment. James versus the United States, and this is from something in 1961. Retroactive punitive measures may reflect a purpose not to prevent dangerous conduct generally, but to impose by legislation a penalty against specific persons or classes of persons. Oh, and I guess you could say something as far as the ex post facto thing, like slavery was outlawed, so you can't punish people for something they did before. You just can't have them now, and we wouldn't want them now. I'm just saying. That was the other thing I was just thinking about when I was reading that, because it said one of the cases from like 1700 something. So anyway, sorry, my mind went off somewhere else. Okay, these well-entrenched constitutional protections and presumptions against retroactive application of legislation established the 18 U.S.C. 20 or subsection 2252A in effect at the time of the alleged conduct applied to the instant action, not the amended version, which added subsection G. Not only is there no clear express intent stating that the statute is to apply retroactively, but even if there was such an intent, which does not exist, applying a later version of the statute would be in clear violation of ex post facto clause of the United States Constitution, as it would be applied to events occurring before its enactment and would increase the penalty or punishment for the alleged crimes. U.S. Constitution, Article 1, subsection 9, Clause 3, and subsection 10, Clause 1, U.S. versus Siegel, and that was from 1998. U.S. versus Edwards, and that was also from 1998. And then Calder versus Bull, and that was from 1798. So, for now, I think we're going to be done with this. This is a long document, and it's, like I said, it's pretty boring reading, like these court cases. Sometimes it's interesting what you learn, because I didn't realize the ex post facto thing had to do with retroactive punishment. But anyway, Yeah, I see how it can be applied. At least I've learned that just in this reading and then looking at the Google thing. But anyway, I will talk to y'all later. Have a good day. Bye.